all our CCR TV viewers a warm welcome. Sogle amche CCR TV polenarank my mogaco yokar. We all know that on 21st December 2023, the Rajya Sabha passed new criminal law bills to replace colonial era IPC, CRPC, Evidence Act with the aim of revamping the Indian criminal justice system of India. Earlier, that's on 20th December 2023, these bills were passed by the Lok Sabha, and around at this time, 141 members of parliament were suspended from both the houses. President Draupadi Murmu gave her assent to the new 3 criminal code bills on December 25th. Previously, the central government had withdrawn the originally introduced 3 criminal bills, namely the Bharatiya Saksha Bill 2023, Bharatiya Nyaya Sanhita BNS 2023, and the Bharatiya Nagrik Suraksha Sanhita BNSS 2023, and introduced the second version of the bills incorporating the amendments and alterations suggested by the Parliamentary Standing Committee chaired by Brijlal, the Rajya Sabha member. There are 3 bills for all of us, and they say that the Bharatiya Sanhita 2023 will replace the Indian Penal Code 1860. Bharatiya Nagrik Suraksha Second Sanhita will replace the Criminal Procedure Code Act 1872, and Bharatiya Saksha Second Adhiniyam will replace the Indian Evidence Act of 1872. What are these new changes and much more? In our program with conversation with a leading lawyer, a constitutional expert, we have Advocate Cleofato Almeida Coutinho of Asolna, and we welcome Advocate Cleofato. Welcome, Advocate Cleofato.
Thank you for having me here.
You have over 30 years of experience
Yes.
in constitutional laws, and you are very well versed with the so-called now IPC, CRPC, and the other acts that you have been teaching in the law college for over 30 years now. What are these new changes that you can share with us?
Before I tell you about the new changes, I would like to make a few opening statements. To a large extent, our constitution is Anglo-Saxon based.
Yes.
It is based upon freedom, rights of individuals, and democracy. The criminal law in our country from 1860 onwards, 1872 onwards, has been based on a very clear civilized jurisprudence. The Indian Penal Code 1860 defined offences. The Criminal Procedure Code was the procedure for investigation, trial and punishment, and the Evidence Act applied to what is admissible and inadmissible evidence for both on civil and criminal side. Now, when you use the word colonial, I have objection to that simply because they may be made in those times. But take the Criminal Procedure Code. It was updated up to 2018. We had a new Criminal Procedure Code in 1973 and updated in 2013-2018. The Indian Penal Code was also updated from time to time. Now, Indian Penal Code is a law which is followed in over 100 countries. For India, it was the Indian Penal Code. If you go to some other countries, it would be the name of that country and the penal code. Now, what are the changes? If you ask me, there are no major changes. Changes are of cosmetic nature. Indian Penal Code is tinkered to about 90%. Criminal Procedure Code about 95%. The Indian Evidence Act is 99% the same. So I would say it is cut and paste job for about 10% for IPC, 5% for CRPC and 1% for the Indian Penal Code. See, when we bring laws, laws have to be progressive. Laws have to make criminal law more just. Laws have to mollify the rigors of criminal law. Now, the changes that have been brought about to a large extent make criminal law more harsher. Of course, there are some changes which are welcome, like community service.
Yes,
Welcome.
that has been introduced.
Yes, it's a
now.
welcome change.
Yes.
Welcome change.
Yes.
Changes in the electronic records.
Yes.
Changes of evidence through video conferencing.
Yes.
Changes through experts. Now, these are
The
changes.
forensic experts.
Yes,
especially.
these are changes which are welcome.
Yes.
But these changes were followed from time to time. Like the Information Technology Act also amended certain changes, made changes to the Indian Evidence Act. So, according to me, we have changed the name of the laws. Earlier, the names were in English. Now, we have the names either in Hindi and Sanskrit. And that is a major change.
So, but in effect, have they retained some of the provisions which we had seen in your criminal laws?
I am saying more than 90% is retained.
More than,
Now, more than 90% is retained in the Indian Penal Code.
yes.
About 95% in the Criminal Procedure Code and about 99% in the Indian Evidence Act. So, I am saying major thing is retained. And the changes that are made are in certain areas, like say sedition is gone,
Yeah, the-
sedition is not there, but there is another provision 252 which makes which brings in similar provision which is so vaguely drafted, and whenever it comes to penal law has to be defined with precision. Penal law has to be defined specifically, and the major question over the new 252 is the vagueness of the law.
But Home Minister Amit Shah said the new bill focuses on delivering justice instead of handing down punishment.
See, this is in the name of the law, like Bharatiya Nyay Samvidhan. I mean Bharatiya Nyay Sanhita.
Yes.
Now that is the change in the law. Earlier it was Indian Penal Code. Now they call it Indian Law Code. So finally, because you have changed the name of the law, does not make the law just. Law, in fact, under the Indian Penal Code, 95% is the same. See, when you are changing the law, according to me, there was a need to take into account various other reforms that were required, like the police reforms. See, the police investigation and crime control
Yes.
should be bifurcated, and the one who controls the crime must not be in charge of investigation. Now, it is this type of measures that even the Supreme Court has recommended over a long period have not been taken into account while drafting these laws.
And what they say is that, I mean, these are all politicians who say all
No,
this.
see, finally, I look at it this way, that the government wanted to leave its imprint.
It was
Or part of their move to leave their imprint on every institution.
And
Here
this-
they have left their imprint on the criminal laws.
And this was one of the 3 objectives of their BJP manifesto.
Maybe. See, if the law has to change, then it has to change. Like the way the police investigates, will have to change. See, I am not saying that there are no major changes made. See, there are changes made, like video conferencing is a change that is made. Then a victim, their statement would be recorded, will be video recorded. That is there. Then there are time limits fixed for courts to complete trial.
Yeah, they say that after the implementation of these laws,
Yeah.
disposal of any criminal case will not take more than 3 years.
See, I do not know whether it is possible to have such a system in place without seeing to it that the infrastructure at the court level is changed. There was a time, some time back, even when the Supreme Court gave directions for closure of certain cases within certain period, it did not happen. One, both in our law, civil law and on the criminal side, the trial has to start and end. It has to be on day-to-day basis. But it does not happen. It does not happen because the amount of time that is required for other matters, the courts can't give.
The backlog is,
Yes, the infrastructure at the court level is unable to deal with day-to-day trial of cases. So, that infrastructure will have to change. Now, of course, the government may have an action plan for that also, but that is not in place at this stage. But having said that, I would say fixing of timelines is a good deal. It is a good thing that
Yes,
timelines have
yes,
been fixed.
yes.
But now look at it from another perspective. Was it not possible to change the criminal code, the Indian Penal Code and the Indian Evidence Act by carrying out amendment to the existing law? See, when you say that you are overhauling a law, I would say at least 50% of that law has to change.
Yeah, but
if you are retaining 80-90% of the law, where is the overall?
But the Home Minister Amit Shah now says that the justice system will be based on legislation framed and passed by Indians. From the FIR to judgment, all the processes will be online.
See, I would say the Indian Penal Code, the Criminal Procedure Code, the Indian Evidence Act, as approved by the Indian Parliament, were also Indian laws. It is like the Portuguese Civil Code existing in Goa and approved by the Parliament and applied to our state was an Indian law.
But
we may have in our mind that is a Portuguese law.
But
it
one
is-
can say that there's
now, of course, we have a law passed by the Goa Assembly.
Yeah,
it is
but-
the same law.
Yeah, but somebody can always say that the Portuguese civil code is a colonial and therefore it should be done away with.
No, I would not say that, because of course we are slightly digressing, but the point is whatever is good, whatever is progressive, whatever is progressive compared to others must be retained. What is wrong in that?
So, and in this case it has been retained.
No, I would say the major portion of all the 3 criminal laws is retained.
Yes. So it is just not a change.
It is
in
not
the
a
name.
it is not a major overall. The change is more in the name than in substance.
Okay.
It is a rhetoric.
Okay. Except maybe for your electronic.
Yeah, but if you ask me what is the major issue with this law, I would say it makes the criminal law more harsher. I say so because of, see, earlier the police custody could be within the first 15 days.
15 days.
Now that 15 days could be within the first 60 days or first 90 days.
90
No, I
days.
mean not first, 60 days or 90 days.
Yes.
So the police have a bigger control on the criminal. Now why was this 15 days and why not more? See, for hundreds of years it was known and it was realized,
And it was tested also.
it was tested that police normally extract information by third degree method.
But duress.
Yes. So to avoid this and to restrict this, it was restricted to the first 15 days.
So now they'll have unfettered powers.
Unfettered 15 days for the 90 days.
Yes. And they would do.
Yes, this is not fair to the criminal justice system.
Yes.
And I would say this goes against a very great principle of criminal law, which says that an accused is innocent unless proved guilty. It is their job to prove him guilty.
But here it leaves a vast scope for the police to.
Yes, that is the problem. And finally, please keep in mind, what is our conviction rate? So far the conviction rate is quite poor. Second important part which has to be highlighted is terrorism is now part of a general law.
Yeah, because they have done away with sedition.
No. Terrorism,
Yeah.
which was otherwise a special law under the Unlawful Activities Prevention Act, is now brought as part of general law. So terrorism is in the general law, when terrorism, according to me, is a specific crime. It was decided by the government that such a crime would be investigated by the NIA, National Investigative Agency. Now the SP in a state has a right to decide whether a accused would be tried by NIA or by the regular IPC terrorist law. I would say the SP has been given unnecessary discretion, because wherever there is discretion, there is always misuse of discretion.
But what they say is that the new laws have ended the provisions of sedition and that no one will be punished for criticizing the government. But criticizing the country or tampering with its sovereignty and unity will be met with stringent punishment.
See, anybody questioning, I would not say questioning, anybody having a crime against the state, trying to act against the unity, integrity, sovereignty of the state, must be dealt with firmly. There can be no two opinions on that. But that offence must be defined with precision. The problem with the present 252 under the BNSS is that it is defined vaguely. That is the problem. That we cannot have vagueness in a criminal law. That is BNS 252 of the BNS.
Even when we dealt with terrorism and the other things, the law was very sharp.
No, the law was sharp. The law was sharp, but it is now not that much sharp. See, all the time, see, what happens is, in case of that law, there is no parole, there is no bail, your statement can be used against you. The normal safeguards of a criminal law are not available to the accused.
Today.
No, to the accused under the special law like UAPA.
Yes.
Normal safeguards are not available. He has to prove himself innocent. Now, when you bring in such a law, that offence must be defined with clear precision, and the charge against the law is that the definition is vague.
So with such a vague definition,
Yes.
it could lead to.
Yes, it could lead to injustice to certain people.
Yes.
And see, finally, we have to also keep in mind that how police functions, how courts function, is that wherever there is discretion, there could be misuse of discretion. Now that discretion has to be brought down, and it can be brought down only by clarity. It can be brought down by precision. And if that precision and clarity in the definition is not there, then the police could act malafidely, the courts could misinterpret. So that is the reason why we say that when it comes to such offences, they have to be very sharply defined.
So now all this what you are saying will be known only once this is implemented, and it may take maybe end of the year or whatever.
Correct. No, I do not know how much time they will take to put processes in place, because particularly when they say that the criminal procedure code comes into being, and once the timelines are in place, then for the country to be ready for those timelines, maybe we will have to have more courts, and the present infrastructure may not be in a position to take that load. Now let us see what the action plan of the government is.
Yeah, but they say in 4 or 5 months this could be implemented.
Yes, that is what they say, but I do not know.
Yes, it's quite.
I don't buy that argument.
Yes, but with the introduction also to accommodate the change in technology and in the process for administration and policing, it's quite
see the change in
job.
the change in technology is welcome. There has to be, but according to me, these things were there already in place. I don't think, of course, now they may be part of the Indian Evidence Act. They were there in place under the Information Technology Act. Information Technology Act dealt with all these issues. So, according to me, there is nothing major that has been brought about by these laws.
And what Amit Shah says, that the new laws have been conceptualized based on the thoughts on justice by ancient Indian thinkers. Was not this also in your IPC, CRPC and the others, Evidence Act?
See, I do not know what exactly he meant.
Yes.
But I would say that the Indian Penal Code and particularly the Criminal Procedure Code dealt with great principles of criminal jurisprudence. See, the principle that you are innocent till proved guilty. One, the police have to prove your guilt. You are entitled for silence. These are great principles accepted world over. I am not saying that they are there in our country also, but all the countries in the world accept it, and so many countries have taken steps to further mollify the criminal law. Like we will find death penalty existed in many countries. Today death penalty has been removed by so many countries. See, we have to keep in mind one thing, that we in India sometimes, or rather most of the time, look at punishment through the eyes of retribution and deterrence. Something happens, we want to increase the punishment. See, we brought the NDPS law dealing with narcotics, increased the punishment. Nirbhaya happened, punishment for the rape increased. I am not saying culprit should not be punished. I am only saying, does increased punishment help society, or increased punishment acts against the very giving of punishment? Because finally we will find there will have to be a balance between retribution, deterrence and reformation. See, a criminal also has to be a reformed citizen on one day. The job of the state is to reform him. He has to be reformed.
That's
I'm
why-
not, yes, I'm not saying he should not be punished. He should be punished, and out of that punishment, he should not come out as a more hardened criminal. He should come out as a reformed citizen.
And that's the reason why that penalty has
Been removed. Has been
Yes,
removed.
Yes.
Another thing in the present law I find is the government has too much control on remission of sentences. That control is excessive with the government under the new procedure code.
Now, under the Bharatiya Nyaya Second Sanhita BNS 2023, they say that it defines and adds terrorism as an offence. Community service has been added as a form of punishment. Sedition as an offence has been removed with provision on endangering the sovereignty, unity and integrity of India. Terrorism has been defined. Organized crime has been added as an offence, including offence such as kidnapping, extortion, contract killing, land grabbing, financial scams and cyber crime carried out on behalf of a crime syndicate. Mob lynching has been introduced as an offence. Were all this not covered under the previous acts?
Many of them were covered generally. Many of them were not covered specifically, like say take the case of mob lynching. Mob lynching may be covered if there is a death under 302, which was death. Now that mob lynching has a connotation of say race, community, caste, that is there. So I would say redefinition of certain offences like land grabbing, mob lynching and cyber crimes are good. There is no doubt about it. Certain crimes had to be defined, they have been defined. But according to me, they fall in the 10% which I spoke about. That the changes that are there are in this 10% which I have been talking about. 90% has been retained.
90% has been retained.
Yes, these all whatever you have spoken just now falls in the 10%.
Okay. And the key highlights of the Bharatiya Saksha second bill: classification of electronic records as documents and includes information stored in semiconductor memory or any communication devices. Introduction of electronic oral evidence, comprehensive certificate for submitting electronic evidence, secondary evidence to include oral and written admissions, and a testimony of a person who has examined a document and is skilled to examine the documents. Emphasis, they say, is on digitization, information technology, provision for mandatory video recording of search and seizure procedures.
See, mandatory video recording of search and seizure, video recording of statements of victims, digitization of records is all welcome. It is good. It is keeping in with the times. According to me, these are good measures, progressive measures, and they are welcome measures. But as far as I am saying, that this is nothing new. This has been there existing. In fact, we have been following it. You will realize that even during COVID times, we have been having this recording of since COVID times. We have been having trials through video conferencing.
Yeah,
So
even now
we have been having.
Yes,
So
yes.
it is not that, of course, now it is there in place as a part of the law. But it has been there, we have been following it. So all that I am trying to say is there is nothing major overall. There is nothing major.
And third, the key highlights of the Bharatiya Nagrik Suraksha second Sanhita is 15 days of police custody with part authorization during the initial 40 or 60 days of the 60 or 90 days period of judicial custody. Allows the use of handcuffs by police officers in certain cases, and any police officer can request a medical examination of the accused in certain cases, including rape cases. And the last is the magistrate can order any person to provide finger impressions and voice samples.
Correct. See, this is what I am saying. Like say handcuffing. The Supreme Court has come down heavily on handcuffing. I am not at all dealing with a criminal who will run away. We are dealing with criminals who will not run away. If a criminal will run away, then the police has to give reasons and can handcuff him. There is no problem. Even the Supreme Court has said that. But the court has said that handcuffing a person is no good. It is not a human act. And now what the law says, law permits it. So according to me, this is a retrograde act. And when you say that 15 days is now available to the police between 90 days, according to me, that makes criminal law more harsh.
It will be definitely more
harsh.
Yes. And do you think that these key changes will result in a decrease in all these offences?
See, changes in law, changes in punishment may not result in decrease of offences. I would say we have seen that at least in the past more than one decade, whenever there is a major crime, the society also wants increased punishment. But that increased punishment has not led to decrease in offences. It is not so. It has not happened. So, let us take the case of the narcotic sin. Has the NDPS law brought down the drug sin anywhere?
No, it's exactly the opposite is the effect.
So, if you say exactly the opposite is the effect, then how do you say that the laws like this help? Anyway, let us see how it works out.
Yeah.
But to my mind, this is only cosmetic and they have changed the name.
Now, during this course of passing of these bills, nearly 141 members of parliament were suspended and mostly of the opposition. Was it a good procedure?
See, the entire parliamentary facade depends on discussion and debate. If there is no debate, that is death of parliamentary democracy. And in this case, I would say it was death of a debate, death of discussion. And that is how I would say that the bills, if they are so important, it was required that the entire parliament was present, discussed and debated the bill. The bills would have come finer, sharper, better, and maybe the government would have accepted certain provisions suggested by the members who are now suspended.
Yeah, but in any case, they have the majority and they could have jolly well passed all the three bills.
That is right. See, but that is not how a democracy has to function.
Yes.
That is not the way parliamentary democracy has to function. That is not fair to the country.
A debate is always welcome.
Debate is welcome, and debate is the fulcrum of a parliamentary democracy.
And one can have divergent
Of course,
views.
you can have divergent
in a
views.
democracy.
See, according to me, dissent is the flavor of democracy. If democracy has to flourish, debate has to flourish, dissent has to flourish.
So I think the new criminal laws are likely to come into force only after some months, and they say the intervening period will be 4 to 6 months. They have to prepare and equip the criminal justice system for a smooth transition. That transition, especially for the police, will have to be quite tough.
I hope the police are better equipped. I hope the infrastructure in the courts is made better. I hope we get more courts, more competent courts, so that the crime scene is controlled.
So the full implementation of the laws involving updating of criminal justice infrastructure, software, training of human resources and complete computerization of courts is expected to take much longer, with a targeted December 2024 timeline for all the union territories. Time is needed for publishing of books containing the codified laws and reaching them to law enforcement agencies, right down to the beat constable, lawyers, prosecutors and all levels of judiciary, particularly the lower judiciary. What is your final take on these three new laws?
My final take is that the new laws change the criminal law only cosmetically. I feel that it is a rhetoric, because the major chunk of the three laws remain, and whatever changes are made make the criminal law more harsher.
So I think various systemic changes will be needed to be made before police start registering FIRs as per the provisions of new criminal justice codes. Are you happy at the way that our investigations are now happening?
Personally, I am not happy, because see, there is too much of government intervention in the police administration. If you look at the way our MLAs, our ministers, our governments function, the first control they want is over the police.
Yes.
The first ministry MLA wants becoming minister is the Home Ministry. See, and why do they want this? Because they want to control citizens through the police. According to me, that is the problem. That, and one more thing is, I have said this earlier, we have missed an opportunity to insulate police investigation from other wings of the police.
But no present dispensation of the government would want to have such a separation.
I hope some government comes which helps in that direction.
Finally, Amit Shah said that making laws simplified, as now they have done, was among the three promises made by the BJP in its poll manifesto. The others being construction of Ram Temple, 33% reservation for women in assemblies and parliament. What is in store for us, only time will tell. Thank you, Advocate Cleofato, for being with us. You have spent your valuable time, and let us keep a track on what is happening.
Thank you
very much.
Thank you, CCR TV.